When the Constitution was written, no one ever imagined GPS technology, but those words in the Constitution have to be applied today, and the justices did it in this decision.
Absolutely. Unreasonable searches and seizures was the term they used in the 18th century, and now they had to figure out what that means for GPS. It was very interesting. Unanimously, the court agreed that you needed a warrant. But the court split 5-4 about why the reasons were. Justice Scalia, who wrote the majority opinion for 5 justices, said, this is just like trespassing. Sticking this GPS on the car is like trespassing on someone's property. Justice Alito, who wrote for the other 4 justices, said, no, it's not like trespassing at all. It's that we all have a reasonable expectation of privacy in our cars. And in order to honor that reasonable expectation of privacy, you need to get a warrant. And so that's the division. We can be sure that they'll be returning to this subject again.
Now, did you just say that 2 of the conservative justices disagreed on this reasoning?
Yeah, very unusual in that respect. Justice Scalia was with the other conservatives and Justice Sotomayor, and the 4 dissenters were, well, the 4 concurs were Justice Alito, who wrote the opinion, and 3 other liberals, Justice Ginsburg, Breyer, and Kagan. So, you know, usually the lines are reliable, but in a case like this, it wasn't as politically predictable as usual.
So what does this tell us about the makeup of these 9 justices?
Well, it says that in certain issues, there are not the intense political disagreements that we see in cases like Citizens United or abortion or affirmative action. I mean, here in new technology, they really all are feeling their way. They're trying to figure out what it means. I mean, this has come up in file sharing on the internet. How does that affect copyright? Those kinds of issues, GPS, they tend not to have the intense political divisions that the others do. They're all trying to figure it out.